Well, good afternoon, everyone. I have 2 o'clock, and so to be conscious of everyone's time, I want to go ahead and get started, but we may hear a few beeps as people join us as we go along. But I want to welcome everyone to our 4th webinar in our new webinar series here at the National Sea Grant Law Center. The goal of the series is to share information on the National Sea Grant Law Center's current research and projects. I encourage you to type questions into the chat box as they come to you as we go through the webinar. If I see them, I'll answer them as we go, but there will also be plenty of time for question and answers at the end. And so if you type your questions into the chat box, it's a little easier than trying to coordinate people unmuting lines and those type of things. For those of you who are not familiar with the National Sea Grant Law Center, we were established in 2002 to provide legal research, education, and outreach services to the Sea Grant College programs around the country and their constituents. And we work on a wide variety of ocean, coastal, freshwater, and environmental law issues because we are receiving questions from around the country and we are working with partners from around the country. And today the webinar is focused on our work related to aquatic invasive species. So just some background, which many of you probably already know if you're familiar with some of our work or work in this area about why we work on invasive species. But from the National Sea Grant College Program's perspective, aquatic invasive species have always been a priority issue. Invasive species, of course, pose significant environmental and economic threats to aquatic ecosystems. To address these threats, federal, state, and local governments have enacted numerous laws and regulations, and they spend significant sums of money to prevent, control, and in some cases eradicate invasive species. And so for that reason, obviously invasive species management is a significant policy issue because of the amount of government investment towards the threat. But invasive species can be introduced into the environment in a multitude of ways, and like most animals and plants and species, they rarely respect jurisdictional boundaries. And so invasive species management raises many challenging multi-jurisdictional law and policy questions. And so from our perspective here at the National Sea Grant Law Center, not only are they very interesting questions to look at and to work on, but it's not an area that a lot of attorneys are working on. Very few law firms are involved in this issue. Not many law professors actually specialize in invasive species. And so there is a real information need and significant research gaps with respect to invasive species. And so a lot of what we work on is attempting to fill those gaps. And the National Sea Grant Law Center has actually developed our invasive species expertise pretty early on. As I mentioned, the Law Center was established in 2002, and legal questions related to invasive species have dominated our advisory service, or at least they did dominate in the beginning. The advisory service, our advisory service here at the National Sea Grant Law Center, is a non-advocacy legal research service that's provided free of charge to the Sea Grant programs. So Sea Grant extension agents, other staff, others working with Sea Grant programs can submit legal questions to us that arise during the course of their work. And then the National Sea Grant Law Center attorneys conduct research to answer those questions. Most of the advisory requests result in short memorandum of law, but larger projects may result in white papers or other type of products. We also work with programs to translate legal research into other formats, such as fact sheets. And so I just wanted to share a sampling of the type of research requests that we have fulfilled over the years through our advisory service. And you can see they go back pretty early to 2004. These are also all available on our website, which I'll show you in a minute. But we've done everything from looking at laws regulating the sale and transportation of certain species across state lines, which raises issues of commerce clause, like interstate conflicts. We did a white paper related to the restrictions on the use of tributyl tin and copper, and that was for a meeting that was happening with respect to invasive species management of whole transport. We've looked at illegal stocking of fish, the classification of invasive species as pollutants. One of our big focuses over the years has been on ballast water regulation in the Great Lakes because of the amount of how it was driven in part by litigation coming out of California, but also each of the states in the Great Lakes has their own take on the ballast water regulation, and then you also have EPA and Coast Guard regulation, so it's very complex. Overlaid all of that is international law with respect to ballast water transport and management, and so we've done a series of memos and articles about that issue, and then we also worked with a couple of the programs in the Great Lakes states to do fact sheets summarizing some of the state laws and restrictions on purchasing and selling aquatic plants and fish. But just to show you, every advisory service memo that we do is publicly available on our website, and so I wanted to take you to our website. This is just the home page. You'll see at the top there is a tab for advisory, and if you click on there, then you can find all of the advisory service memos that we've done over the years. They're not all listed in invasive species. Some are under ballast water, and then we also do have a category for invasive species. So a few are scattered in different places. But if you click on invasive species, you can see the various requests that we've done over the years and then download those memos. So in addition to the advisory service, which is really a constituent-driven service, there we're responding to questions that we receive. National Sea Grant Law Center attorneys also engage in traditional academic research to either fill research gaps or to explore emerging issues that we feel just aren't on people's radars yet. Sometimes these research needs are identified by partner organizations. So in some of the projects that we're working on, there's more of a theoretical question that maybe doesn't fit well with the advisory service, but we know that people are interested in research on that topic. And other times they're just personal interests here from the attorneys in the office or driven by just kind of general conversations of what's happening. Here is just a few articles that we've published in recent years with respect to invasive species. The one on the regulatory framework for genetic biocontrol of invasive fish was actually part of proceedings from a conference that was held a couple years ago on genetic biocontrol of invasive fish. The Confronting the Marine Invasive Species in the Climate Change Impact was published in 2014, and then most recently the Natural Resources Journal, which is published by the University of New Mexico School of Law, was doing a special issue of the journal for the 50th anniversary of the National Park Service, which is this year. And so we submitted an abstract and were accepted to write an article about facilitating cooperation between the states and the National Park Service when you have a situation such as a water body that has shared boundaries, or if you have an environmental threat like invasive species, which does cross those jurisdictional lines. Not all of these articles are yet posted on our website. If you're interested in any of these, you can just email me after the webinar or at any time, and I'm happy to get you a copy of these. But in recent years, the National Sea Grant Law Center has primarily focused on our partnerships with the regional panels of the Aquatic Nuisance Species Task Force. And it's become, in our catchphrase, our building consensus work. This partnership arose out of a pilot workshop that was co-sponsored by the National Sea Grant Law Center and the National Association of Attorneys General, or NAG, in 2011. This workshop, which was held at the NAG offices in Washington, D.C., was designed to raise awareness among Attorney General offices of the environmental and economic impact of invasive species. And so the way that a lot of Attorney General offices are assigned is some states do assign attorneys to work with particular agencies on an ongoing basis. But even in those cases, the attorneys that are assigned to work with like a fish and wildlife agency or other natural resource agency may not have an environmental law background. And in other states, the attorneys may be assigned to cases as they come. And again, they may not have an ongoing relationship with the agency or an environmental law background. So in situations with invasive species that is not as well known, it's not often covered in law school, even in environmental law programs. And so there is a need for continuing legal education among Attorney General's offices to keep them apprised of the most current legal developments with respect to invasive species management, but also to help them understand why these issues are important to the agencies that they're representing. And so this workshop was designed to do that, to provide some continuing education and to share information about the economic and environmental impacts of invasive species and what issues were kind of currently going on in the Chesapeake Bay that it would be good for the Attorney General offices to know about. So 15 individuals from 5 states and the District of Columbia attended the pilot workshop. Of those attendees, most were from Attorney General offices, but there were also some attorneys from state agencies and also some state agency personnel. And we received very positive feedback on that workshop, and contacts at the U.S. Fish and Wildlife Service encouraged the National Sea Grant Law Center and NAG to conduct similar workshops in other regions. And so we were encouraged to approach the various regional panels of the ANS task force to kind of offer the workshop to them. And the Western Regional Panel was actually the first regional panel to take us up on that offer to do a workshop for their region. We had envisioned another kind of 3/4 day, full day workshop like we did in the Chesapeake Bay, but the Western Regional Panel was very excited about this opportunity, and they took it to a whole new level that we really would not have anticipated at the time. And in August 2012, the Western Regional Panel, the Law Center, NAG, and several other partners organized and co-sponsored a dracenid mussel workshop in Phoenix, Arizona. And at that workshop, Assistant Attorney Generals, Natural Resource Agency attorneys, law enforcement supervisors, and the AIS coordinators in the 19 western states came together to discuss the management of the trailered boat vector in the region. And so the movement of recreational boats across state lines and in between water bodies, which is a significant concern if they are potentially moving zebra and quagga mussels between these water bodies. And one of the things that was really amazing to me when I first started working on this project is just the amount of overland transport of boats in the region. And the image on the left is one of the maps that was created to show where boats were coming from into a particular inspection station in Idaho. And so you can see that many of the boats are traveling long distances and lots from the East Coast where zebra mussels are present in waters. And so that the concern is being driven from there. To address the threat of overland transport of mussels, Most of the states in the West have developed watercraft inspection and decontamination programs where they actually set up checkpoints. And recreational boaters must stop at the checkpoints and have their boats inspected or decontaminated. In places where there are not check stations, there are still requirements that the boaters inspect their boats, remove all visible plants, animals, mud, drain any of the compartments like the bilge tanks and the engines, and dry for a certain amount of time in some states. And so they're very comprehensive programs to try to deal with this threat. At the end of the workshop, the participants drafted an action plan to implement legal and regulatory efforts to minimize the expansion of invasive mussels through this vector. And the Building Consensus in the West initiative kind of emerged out of the region's efforts to implement this action plan. And since the 2012 workshop, there have been numerous conference calls, many meetings, in-person meetings, and workshops have been held with the AIS coordinators, assistant attorney generals, law enforcement supervisors, and federal representatives in the region to develop minimum standards and protocols for watercraft inspection and decontamination programs. And so that's where this building consensus idea comes from, is that you need, in order to really address any of these problems that happen across state lines, in order for the states to work together, their rules and regulations and standards and protocols need to be coordinated, or at least close enough that they really can work together, and they need to be enforceable, and everybody needs to be on the same page in order for the problems to adequately be addressed. And so the idea is to bring together these three key players in the development of law and policy on the state level, which is the natural resource managers, the law enforcement personnel, and the assistant and the attorney general's offices, which either are writing the laws or helping to enforce them, and to facilitate conversations across state lines so that you can identify problem areas and build consensus on how to move forward and address those problems. And to facilitate the translation of the minimum standards that the Western states are developing into legal obligations, and to promote interstate reciprocity. So in the future, if two states want to work together, say with respect to their inspection stations, and they may wish to enter into an interstate agreement or a memorandum of understanding, we would want them to have kind of standard protocols, laws that are similar, or at least provide the agencies with similar authorities, so that it's easier for them to work together if they so choose. And to help this process, the National Sea Grant Law Center and the Association of Fish and Wildlife Agencies received funding in August of 2013 from the U.S. Fish and Wildlife Service to develop a model law and regulation for these watercraft inspection services or programs. In April 2014, the National Sea Grant Law Center and AFWA released our model legislation. So it's called Preventing the Spread of Aquatic Invasive Species by Recreational Boats, Model Legislative Provisions and Guidance to Promote Reciprocity Among State Watercraft Inspection and Decontamination Programs. And so this document is not designed in a traditional model law format. It's not intended to be kind of adopted verbatim by states. Most of the states, Western states, already have laws on their books that address, either authorize their watercraft inspection programs or touch on invasive species issues. And so this document was really intended to provide a framework for what authorities are needed to provide a foundation for working together across state lines. And then model language is provided in case states do want to fill gaps in their own state law. Then they have a place to start. They can take the model language and tweak it as needed to work with their states. And so there's both the model legislative language and also explanatory notes to kind of guide how states can approach developing these watercraft programs in a way that facilitates interstate cooperation. After we released the model legislation, we received, a lot of questions about, well, what states are closest to the model or what states have pieces of the model. And so to assist state natural resource managers and policymakers in identifying commonalities, differences, and gaps among the states, we undertook a review of each state watercraft inspection and decontamination laws and regulations to see how each state program compared to the authorities set forth in the model legislation. So that companion report, the companion report to the model legislation, was released in October 2014, and it contains an executive summary that discusses our findings for all 50 states and also detailed state-by-state comparisons for the 16 states at the time that had watercraft inspection and decontamination programs. And I just put up a quick infographic that we have put together in October 2014, kind of showing how many pieces of the model legislation the various states had. This chart is very out of date now because the Western states are very active in updating and modifying their laws and regulations, partly because of this Building Consensus initiative. So they're always updating their regulations. Many of the states now have more pieces of the model than what this chart shows. And we will be working to update the companion report later this year after we release the model regulations, which I will talk about in a minute. So the second phase of the project, so the model legislation was first. The model regulations are the second piece. So how can states implement or translate the authority from the model legislation into on-the-ground regulations for running their inspection programs? But before work could really begin on drafting the model regulations, we really needed consensus among the natural resource agencies about the policy framework for their watercraft inspection and decontamination programs. Why? What are the policy goals of the programs? How do you handle things like when those inspection stations are open, where should the inspection stations be located to best facilitate interstate cooperation, who should be authorized to do inspections, how do you recognize those authorizations between states, lots of questions that the state agencies needed to talk about. And so we started initially with developing a regional policy framework that was finalized in August of last year. And now we have developed a draft of the model regulations based on that policy framework. The draft model regulations were completed in January, and we had actually hoped to have them done this summer, but a workshop that we were planning on having in February with the AIS coordinators was canceled due to the snowstorm that hit Denver in February. And that meeting was actually rescheduled and is happening next week. And so we will be getting together with the coordinators from the Western states who will be reviewing the draft regulation text, along with a number of other issues that the group wants to discuss. And then we'll be working with a working group that we have that's made up of law enforcement, assistant attorney generals, and representatives from the AIS coordinators to finalize that text and develop the model regulations. And we hope to have them finalized and out by the end of the year. So after kind of information started to get out about the work that we were doing with the Western Regional Panel, a number of presentations were given at the ANS task force meetings. Also, a number of the panel coordinators were talking and kind of circled back to the original offer that we had to work with any of the regional panels on kind of a similar activity, whether it's hosting a workshop or trying to do a different type of building consensus activity. And in 2014, the National Sea Grant Law Center, the National Association of Attorneys General, and the Environmental Law Institute received funding from the Mid-Atlantic panel to improve regional understanding of the strategies available to access private land for eradication and control of aquatic nuisance species, and also to try to lay the foundation for collaborative development of guidance or implementation. And so the issue here is that most of the time when you have control or eradication efforts, property owners are happy and willing to work with the natural resource agencies to open their lands to control efforts, but sometimes you may have a landowner that is not cooperating or is holding out, and the question is what authority is there for the state to undertake control or to get access to that private land. And so as part of this project, we were trying to lay the foundation for a building consensus type activity in the Mid-Atlantic region. And so we started by undertaking an inventory and analysis of state laws and regulations in the 8 Mid-Atlantic states and the District of Columbia that govern access to private land, and also trying to identify key legal counsel within the state attorney general offices and the natural resource agencies who are assigned to work on invasive species issues, with the idea that then they could be engaged in the work of the Mid-Atlantic panel to address these questions. And we had hoped to also convene a small working group of state attorneys, law enforcement supervisors, and AIS coordinators to actually identify potential strategies to explore. Each regional panel is structured a little differently, and they all operate a little differently. And we, during the course of the project, the level of direct engagement that we were having with the state natural resource agency staff was a little lower in the Mid-Atlantic panel than in the West. So we had a number of states that were very active and interested in the project, but there were a few states where we just weren't able to get a lot of the feedback and information that we needed. And so we decided not to convene the working group and focus on really just doing the legal research and information gathering that would be needed if the panel wanted to take the next step and try to convene a group of people to talk about this particular issue or to work towards interstate strategies. And so the final report was submitted to the panel in October 2015. We do have state summaries from each of the states. We have our list of the contacts that we were able to identify. And in there, we encouraged the Mid-Atlantic panel to consider forming a small committee to explore possible next steps and to build on this work. So we're hoping that in the future, if there's a little more funding becomes available or the states become a little more interested in it, it could be that at the time that we were doing the project, there wasn't any kind of crisis going on with respect to accessing private land the way the mussel crisis is happening in the West. And so it's often hard for agencies to work on issues when they're not actually kind of pressing questions that have to be addressed in order to implement a project. So that report is available, and I think it does provide a good foundation just to look and see how different the states do address this issue, because some states agencies have a lot of authority to access private land, and other states don't have any. And so it's always challenging then if you were trying to work across state lines. And finally, our most recent partnership with the panels is with the Mississippi River Basin Panel. The panel's outreach committee has been interested in organizing an interdisciplinary workshop for some time, which is similar to the pilot workshop that we held in the Chesapeake Bay. So the panel really feels that what we need as a first step is just to try to gauge interest and whether the panel and the states want to try to address an issue that is crossing state lines. And so the panel has decided they wanted to focus on organisms in trade, and specifically bait fish. Bait fish, like the recreational boat pathway, bait fish are moving across state lines all the time. The states all have rules, laws, and regulations governing the movement of bait fish, and there is a lot of inconsistency among the states. There's a lot of gaps. And so it's a good one to potentially consider for building consensus type activities, because there's a lot of unknowns. There's a lot of work that would have to be done to gather information about what is on the books in the states and how those state laws interact and what that means for a person who is moving bait fish across state lines. And so the Upper Midwest Invasive Species Conference, which is happening in October, the conference planners were generously allowed us to incorporate our workshop into their conference, which will be in La Crosse, Wisconsin, as a means of integrating the Mississippi River Basin workshop into the Upper Midwest Invasive Species Conference. The panel and the National Sea Grant Law Center are organizing a standard session on organisms in trade. That session will occur, hopefully, if it's accepted, the abstract, if it's accepted, will happen on October 18th. And the presentations will address a range of topics, including a broad overview of the organisms in trade pathway, the challenges presented by internet trade in species, which is a huge problem. Many of these species are traded over the internet, and it's easy to ship them and get them, purchase them wherever you want them. States also have restricted lists, species that aren't allowed to be transported or sold, but the states in the region, everybody's list is a little different, and so that causes confusion and gaps. And there's also a number of federal challenges with respect to the Lacey Act that will be talked about. The Mississippi River Basin Panel Workshop will then happen on the 19th, which is the last day of the conference. It is going to be interdisciplinary. We're going to follow the building consensus model and invite law enforcement, AIS coordinators, and Attorney General's offices to participate, and invitations are going to all of the basin states. So it's actually a really big group. There's 31 states in the Mississippi River Basin. We don't anticipate, because of the distance that some states would have to travel, that we're going to get them all, but we're hoping that we can at least get the ones in the Great Lakes in the Plains region. We are still working on the agenda, but we anticipate that the morning presentations will really focus on information sharing, providing a general overview of the bait fish pathway, providing some information on current state laws and regulations, and also any big issues of concern that could be addressed to really set the stage for afternoon discussions among the participants, which we hope will either identify problem areas, research needs, and also priorities for future action. And so it may be that the group decides that this is something that they want to continue to work on and may be willing to do it in a larger fashion over, a course of a year or a couple meetings to really implement that building consensus model that the Western Regional Panel has been doing. But this workshop initially is just to kind of bring people together, raise awareness, and get them to think about whether or not this is something that they would like to work on. And so what's on the horizon for us is kind of where I wanted to end it was, so in addition to finalizing the model regulations and organizing the Mississippi River Basin Workshop later this summer and into the fall, we will also be working on some outreach related to the federal Lacey Act and the injurious species listings of the Fish and Wildlife Service. So under the Lacey Act, the Fish and Wildlife Service has the authority to list species that are considered injurious to the environment, agriculture in the United States. there is a number of legal developments that are really important to keep an eye on with respect to the Lacey Act. First, there have been 2 new injurious species listings that are generating a lot of discussion and some controversy. In October of last year, the Fish and Wildlife Service issued a proposed rule to list 11 freshwater fish as injurious. They are using a risk assessment model and a new tool to kind of run through whether these species should be listed, and they were identified. These are believed to, they're all foreign species, and it was believed that none of the species were actually present here in the United States, so this would have all restricted the import of these species into the United States. After they issued the proposed rule, there's some information has come to light that maybe a few of the fish species, such as zander, may actually be present in the United States, but it's not really clear if those were intentional introductions, if they're actually in trade, or if maybe they had already been introduced. So stay tuned for kind of what the Fish and Wildlife Service does with the comments that it's been receiving. In January, they issued an interim rule listing salamanders, a number of salamanders, as injurious because of the risk of a fungus that the salamanders are carrying. And so this is raises some questions because some of the salamanders are actually native species, so they're not foreign species, and maybe wouldn't be considered and are not considered invasive species. So it's the fungus that is invasive, and the salamanders are a potential host or carrier of that fungus. And so it's kind of the first time that a native species has been listed in this type of way. And so, again, important to kind of keep an eye on that rule as it moves forward, and questions that may arise about the Fish and Wildlife Service Authority. The bigger challenge happening with respect to the injurious species is the federal court challenge to the constrictor snake listing. So that case is the U.S. Association of Reptile Keepers v. Jewell. Here, the plaintiffs are challenging the authority of the Fish and Wildlife Service to restrict the interstate transport of injurious species. So they're relying on some provisions of the Lacey Act that suggest the Fish and Wildlife Service may only have the authority to restrict the import of injurious species into the United States and the transport of injurious species from the United States to the islands like Hawaii or Puerto Rico. So the initial, right now it's in the district court. The district court had ruled that the plaintiffs were likely to succeed on summary judgment, that they raised issues that suggested they were going to succeed on the merits with respect to the Fish and Wildlife Service jurisdiction. They issued a stay of the rule. The Fish and Wildlife Service has appealed that district court opinion just last week or 2 weeks ago. There were hearings in the D.C. Circuit Court with respect to that appeal, and we will remain to see how that case moves forward. We did write an article for the most previous issue of the Sandbar that covers that court case, and we'll continue to cover the developments of that case as they move forward. So stay tuned. There's a lot happening right now with respect to the Lacey Act, and it's important to just kind of keep track of what the agency is doing and how they're being challenged by various groups. And so that was kind of the overview that I wanted to give everybody today. Like I mentioned, if you have any questions or want more details about something, please use the chat box, and I can try to answer them now. All of the information that I've covered today, most of it is available on our website. Some of the newer publications haven't quite made it up yet, but we do have a project page on our website for the Building Consensus in the West work. And so on that page, you can find the model legislation and the companion report, as well as a series of law review articles that came out following the Phoenix workshop. And if you can't find something, please email me at any time at the email address on the screen, and I'm happy to get you any of that information. So I'll just see if anyone has any questions. Okay. Well, if not, if nobody has any questions that they want to post to the group, completely understandable, then I think we will wrap up. And I really do appreciate everyone joining us today. If you know of somebody who wasn't able to make it, the webinar has been recorded, and we will post it. It'll probably be up by next week. And so I will send an email out about that as well. But thanks again.